to our broadcast today. My name is Cindy Speaker, and I have with me as my guest workers' compensation attorney Bill Kowalczyk of Michael J. O'Connor and Associates. Bill, thanks for being with us again.
Good morning, Cindy. It's always a pleasure.
Same here. Well, Bill, we're going to talk about workers' compensation, and we're looking forward to you sharing a little bit about how do workers' compensation benefits interact with other types of benefits, such as unemployment compensation.
Right. Yeah, very important area. When an individual comes to us to be represented, it's important for us to take into account everything else that they may be entitled to in addition to workers' comp. And the reason is those benefits affect each other. And we have to evaluate and assess what's best for the person to advise them.
Right.
So, for instance, unemployment compensation. It didn't used to be this way, but a number of years ago, the legislature changed the law such that if you received unemployment benefits, you couldn't receive them concurrent with workers' comp. So the workers' comp would get the right to reduce your benefits based on your receipt of unemployment, your net unemployment that you would get your monthly benefit. Now, this comes into account often when somebody is separated from employment and hurt at the same time. So, you'll get people who shortly after they were injured, they were terminated or laid off, or it applies to people who are on workers' comp or on light duty and the plant closes and they're entitled to unemployment. So generally, what we're going to say to people is if you're receiving the workers' comp benefits, you shouldn't attempt to go on unemployment. That's our first advice because it's just going to reduce your workers' comp.
I see.
And that's not in your best interest. Workers' comp is a superior benefit. You should get that mostly. However, there are times when someone comes to me with a denied claim. And if they have a denied claim, what that means is I'm going to have to go to court to get those benefits for that individual. So they're not receiving workers' comp benefits, but they're injured and they're unable to do their usual employment. If they also happen to be separated from employment, they may be entitled to unemployment benefits during the period of time that we are in court litigating, and that allows people to sustain themselves with some income until they get their workers' comp. Now, when they get it, the insurance company is going to owe them retroactive to when they were first injured. However, they're going to get a credit for all the unemployment that was received by that individual, which is fine because they needed that money in the interim. So that's how it comes into play. And the thing about unemployment that a lot of people don't understand is this. If you're injured and you're unable to work at all, you're not eligible for unemployment. To get unemployment, you have to be able to work in some capacity. So it's available to people who are not totally disabled, but say partially disabled. They can't do the heavy job, but they're released to do some type of light work. Those people can get unemployment and still move forward with their workers' comp because in that forum, they're trying to prove they are disabled from their usual, usually more heavy job. Okay,
Right.
So that's the first benefit, one of the most common ones that we see. Another one that we come across a lot is the Department of Human Services of Pennsylvania. People who don't have health insurance, we find, often will apply for medical insurance through the Department of Human Services. Used to be the Department of Public Welfare. Same thing, but they will receive some type of health insurance. And it used to be that health insurance was provided by the Commonwealth, but now they are contracting that out to various private health insurance companies like Geisinger or Aetna. So somebody will end up with a coverage paid for by the state. Now, the reason that's significant is, again, in these situations where someone has a denied claim, we often find, well, They have no health insurance. They have no way to treat if they have a denied claim. So they go to the state, they get this insurance. That insurance pays for their treatment in the interim while I'm litigating and trying to make it work related.
Right.
However, we have to account for that. That becomes what is called a lien. And at the time we are either victorious or we settle it, the Commonwealth has to be paid back
I see.
by the liable workers' comp insurance. So that's another thing that we have to take into consideration because it's something that can't be overlooked. You can't ignore it.
Right.
By operation of law, they have a lien, so we got to pay back the state in all instances. Also, what we find is Social Security disability is another concurrent benefit that a lot of clients will come into. Now, generally, we will say to people that if you feel you're totally disabled, Social Security disability may be an option along with workers' comp. And whether or not you should do it immediately is the question. So this is where legal advice comes in. Some people, if they've had a devastating injury, I might say to them, look, you might as well file for Social Security disability now because you're never going back to work and you might as well maximize your benefits. So sometimes that'll happen. But in most instances, when the injury is not, immediately catastrophic or totally disabling, I will say to people, let's hold off on that Social Security until we settle your comp. And there's a reason for that, because once you're on Social Security and Medicare, you can't just settle your comp. You have to get Medicare's permission. You have to set up what is called a Medicare set-aside, and sometimes insurance companies are turned off by that cost, and we're unable to resolve the case. So every case is different, and this is where legal advice comes in.
Which is the superior benefit, Social Security disability or work comp?
Social Security disability generally does not pay as much.
Okay.
So that's that. And there's also, you can't collect both, just like in unemployment. Yeah. But in this instance, it's not the comp that takes the credit, it's the Social Security disability.
Okay.
So some people, if they're receiving a significant amount of workers' comp and they want to go on Social Security disability, they will not receive any significant benefit from Social Security disability. Hence, they should wait till the comp is over. Yeah. Some people who have a really significant earning history will receive a nice Social Security disability payment, which allows them to supplement what they're getting. So for people who are, clearly not going back to work, I'd recommend it. But, it's a case-by-case basis on all of that.
Right.
So, and the other issue that comes up is if you're on Medicare, sometimes Medicare pays for a bill that's work-related, a work comp bill, and that's problematic too, because again, under operation of law, that becomes an immediate lien on the case. So we have to account for that. If we're ever going to settle it, Medicare has to be paid back. So you got to watch that.
Right.
Medicare shouldn't be paying for work-related treatment during the time someone has an accepted case. But doctor's office sometimes just bill whoever they bill, and that needs to be taken care of.
Yeah. I can see where attorney advice is so important in these situations.
The mixture of these benefits, some people have more than one. It makes it complicated, so you need to talk to your attorney about this.
Right.
And another one that's sort of like on the same lines as Medicare is private health insurance. So some people, they have private health insurance, and they'll come to us and they've been injured, and the claim is either denied or accepted. And in both instances, whether they have a denied claim or an accepted claim, we find that there are times when their healthcare providers will be billing their private health insurance, whether they should or shouldn't.
No.
They do it. Now, sometimes they do it because there's a denied claim and there's nothing else to bill. We find that all injured workers, when they go to the healthcare provider, are asked, do you have a secondary insurance? That's what providers do. They want that on file. If they're denied by comp, they just bill the health insurance. Now, if they bill them for something that is work-related, that also becomes a lien. but not by operation of law. It's not immediate. What we find is, though, these health insurance companies will advise our client or us directly that they've paid something and they want it back. That's called subrogation. And once they advise us, it's our duty to work that out and make sure they get paid back either during the case or at settlement. So, again, another thing to be cognizant of as a practitioner is, does your client have health insurance, and how's that going to play into the whole thing? And another thing that often comes up with older employees is pension benefits. So you see, there's a number of pension benefits that people may be entitled to at the time they're injured. So for instance, you're injured, you're an older employee, you could retire. Now, if you did that, those pension benefits are going to become a credit against your workers' comp. So obviously, I am going to advise people to not retire until I can settle your workers' comp. Because all that happens when you retire is that you get your pension benefits, but your comp goes down, and in some instances, way down.
Okay.
So that at that point, the settlement value of your case has gone down because the cost to the insurance company has gone way down. So those benefits, pension and severance, sometimes there's severance, both of those are a credit against comp. So that needs to be coordinated with the attorney to make sure that our clients maximize what they get and that it doesn't interfere with their ability to collect going forward and to ultimately settle.
Yeah.
Now, sort of along that line of retirement, we find that the issue of Social Security retirement comes up. Because, once you reach that age, you would be entitled to take your Social Security retirement benefits. And the law is, if you take those benefits after you are injured, 50% of your benefit amount per month is a credit against your workers' comp. So again, that's going to reduce your comp quite a bit. And we don't want that. So we often will tell people to defer retirement until we can resolve those benefits so you can maximize what you get. Also, if you retire, sometimes the insurance company will file a petition to try to stop your benefits under the theory that you have taken yourself out of the workplace and no longer need wage loss benefits.
Okay.
So there's a couple reasons not to do it. Now, there's a loophole in this because there are people who are already on Social Security retirement. And you can still work. You can earn a certain amount of money. And we have those clients. And while they're working, earning this small amount of money, they get hurt. They continue to receive their Social Security retirement, even though they're on comp and there's no credit. So that's a loophole in that because those benefits began before.
Yeah.
So anyway, again,
so
another reason to talk to your attorney about this.
Yeah.
Because there's a lot of different variables. One of the other things that comes up is people will ask me if they get injured and they are thinking about returning to work, what'll happen? Sometimes people, they lose a good job because of an injury. That job was heavy work. And they just can't do it anymore. And they want to go back to work, but they want to do it in a lighter capacity. And it won't pay as much. Maybe it'll be part-time. I don't know. But I explained to them that they can do that. But what it does, it takes their benefits from total disability to partial disability. And once they're on partial disability, that goes for 500 weeks. However, their benefits are going to go down based on their receipt of wages. And generally, what we will say is that you shouldn't go back to work until you've resolved your comp. That's not always practical because if the insurance company doesn't want to settle, and if the individual really needs to work, for their mental health or whatever, and people do, then, I'll tell them to go because productive work is important for people.
Sure.
And a lot of my clients, I find, suffer being off, being useless, sitting around the house hurting, sometimes going back to work is the cure that they need.
Yeah.
So,
Yeah.
but we have to deal with that.
Right.
Now, one of the things you might wonder is how does the insurance company find out about these potential receipt of other benefits? And
Yeah.
that's a good question because there's a system in place for that. And the system includes the sending of forms called verification of employment. These forms are prescribed by the Bureau of Workers' Comp, and every insurance company can send them from time to time. The injured worker must fill them out, and if they don't fill them out and return them in 30 days, they can stop their comp.
Okay.
Just unilaterally like that. So it's very
Wow.
important. We're
Yeah.
representing somebody. We get involved in that. We make sure we tell them, get them to us, and we'll send them back certified mail.
Yeah.
With these forms, they ask, are you receiving Social Security, disability, retirement, pension, severance, unemployment,
I
wages?
see.
It asks all that so
Yeah.
the insurance company can determine if someone is double dipping. So that's how they find out.
Okay.
Now, in Pennsylvania, when we talk about workers' comp, that covers everybody. So if you're an employee under the law, the definition of employee in Pennsylvania, then you're covered by workers' comp. Now, of course, that's assuming your employee, your employer has insurance. That's another issue, and I'll talk a little bit about that in another episode. But as long as they have insurance, you're covered. Now, certain employees within the Commonwealth have other coverage, more superior coverage. And those benefits are called either heart and lung benefits or Act 534, 632 benefits. Those are similar benefits, but they apply to different people. Heart and lung benefits are meant to protect police, uh, firefighters, corrections officers, and other law enforcement type people and first responders. If they are injured in carrying out their duties, they can get heart and lung. Heart and lung is full salary, so you get more than you
Yeah.
would on the workers' comp.
And we
It's
covered this. You covered this in another one. Maybe we'll
I
link
did
that here.
right, but what it occurs to me is when you get these benefits, either heart and lung or 534, again, coordination with the attorney is essential
Yeah.
because I'll explain why. The 534 benefits are for people who were assaulted in state mental institutions. So those people obviously want to collect those benefits initially, but they're also entitled to workers' comp concurrently. So sometimes we find the heart and lung benefits will stop because the law is different there. If they
Okay.
stop, they can go on comp though. So it's up to your attorney to coordinate those benefits to make sure you're maxing out on what you get. And that's why I
Yeah.
bring that up at this time, because
Yeah.
I have a lot of clients like that.
Okay.
Corrections officers, firefighters,
Yeah.
etc. So another big issue when we talk about coordination of benefits or things you may be entitled to when you get hurt is the whole issue of third-party subrogation. So an individual is injured and is injured due to the negligence of a third party. When I say third party, what I mean is someone not connected to the employment. This usually comes up in the context of a car accident. The truck driver is on the road and someone cuts him off and he goes over the bank and he gets hurt. He can both collect workers' comp and sue that other driver. However, what that creates is what is called third-party subrogation.
Yeah.
And it's very complicated, and it's very important for the attorney to be aware of it for a number of reasons, because now all of a sudden, if he's going to sue another insurance company that insured that negligent driver, the workers' comp insurance is subrogated to that award. In other words, they're entitled to get some money back. So we have to be aware of that, especially since the amount that they get back is negotiable. Now, the law provides what they're entitled, but we find we can negotiate this amount.
Okay.
Again, to maximize what the injured worker can get from this. And I say to a lot of people, sometimes you never get fully compensated for your injury, particularly if it's really severe. But if there's a third party case, that allows you to go to another source for more compensation for your long lasting
Right.
disability. And that's
Okay.
third party subrogation. So, anyway, not only do practitioners such as myself need to be aware of all these other benefits and incomes to coordinate what's best for the individual while they're receiving comp, while they're in the middle of the case. Also, at the end of the case, when we're trying to settle it, we have to be aware of how these things affect settlement. One of the biggest things I try to
Okay.
explain to people is the fact that your workers' comp benefits may be being reduced in the near future is going to reduce the amount the settlement is going to be, because settlement workers' comp is about the future. It's not about the past. It's about how much are you costing this insurance company. And if you're about ready to retire and they know it, they're not going to want to pay you a lot, because once you retire, they're going to be relieved of a lot
Right.
of money.
Yeah.
So all these issues, and with the heart and lung, sometimes we can settle those together with the workers' comp, get you a little extra money for that. We have to be aware, who do we have to pay back when we settle it? We pay back the state, a health insurance company, and if we do, the insurance company has to pay them back. So that's making it more expensive for them. How do we roll this up in a package so they can live with it and get our client what they're entitled to? So that's basically my feeling
Yeah.
on coordination of benefits and how it
Yeah.
rolls into settlement.
It's interesting that I don't think the average person is aware of how complicated this is, but just listening to what you're saying and all this interaction, it really is I just think everyone really needs to have an attorney involved in these situations, because there's no way they would know all of this.
Correct. And there are many times people will come to us after they've accepted another benefit that affects their comp.
Yeah.
And I say to them, well, you've hurt your case.
Yeah.
You should have come to me early. And I think and just for this advice, people get hurt, they should come to the lawyer immediately. It doesn't cost you anything.
Right.
And if you get some good advice about what you should apply for and not apply for, and how to time that, you're helping yourself.
Yeah. Yeah. Before we go, we have a couple minutes, Bill. Anything new in the law relative to workers' compensation?
One of the hottest things right now continues to be House Bill 1840. And my colleague, Jerry Mullery, is on the Labor Committee in the House of Representatives of Pennsylvania. So he and I talk on a regular basis about the status of these workers' comp bills that are pending. And, just brief background, of course, the Supreme Court and the Commonwealth Court of Pennsylvania both ruled that a section of the Pennsylvania Workers' Comp Act was unconstitutional as it pertains to impairment rating evaluations. Since then, the legislature has been attempting to fix it. So they, like any legislature, they can't just fix it. They have to create other things that each side wants and put it in the bill.
Right.
So they're currently negotiating over that. It's an easy fix. Believe me, it is. So the fix is, and the idea is, to just make it the 6th edition of the AMA guides, which is the most current. That way, in the past, what the court had a problem with was it changing all the time without the legislature approving it. Now they're going to specify. Fine, that fixes it. Now the issue of retroactivity has come up. What about all those people that had their 500 weeks? And that's the essential part of this partial disability.
I see.
Limiting a claim to 500 weeks.
Okay.
And if that's running out, now it's unconstitutional. Now what? Do you get those 500 weeks back? I say yes. However, they want to put in this new bill that the insurance company gets credit for all those partial disability weeks so that somebody now under the new law doesn't get to start over with a new 500 weeks of disability, but rather whatever they have left. There's fighting over that right now. And there's a question about whether that putting that retroactivity in there would even be constitutional. So what I'm concerned about is, even if this bill does pass or these amendments take place, there's going to be more litigation. And this IRE question will not be settled in Pennsylvania for a number of years. They're also talking about the percentage. So right now, the law is if you're under 50% disabled, you are now, partially disabled. If you're over 50, you get to stay on total. We could move that number down, and they've talked about 30, 25, which would theoretically potentially make it easier for some injured workers to stay on total disability. Yeah. So that kind of negotiation is going on right now, and it's not final, but I expect it to come up for a vote in the next couple of weeks, and all the legal experts are weighing in on this right now.
Okay. Well, you'll have to keep us posted on that.
Okay. Sure.
So soon to come. Well, listen, Bill, we're out of time today, but thank you so much for your time, and tell us how we can reach you if someone has questions. Maybe they want to talk to you personally.
Mm-hmm. Right. So you can always go to our website, www.o'connorlaw.com, and we have an 800 number, 1-800-418-4LAW, and you could call us anytime for a free consultation and talk to myself or one of the other attorneys.
Outstanding. Thanks so much for your time today.
Okay. Thank you, Cindy.
Okay, and to those of you watching, if you have questions or comments, you can leave them right on this page. We'll make sure we get them answered for you. Thanks, everybody, and have a great day.